Hello everyone, welcome to the channel. Hereby we have reached to the Holy Article 21, Right to Life, as generally said, and the title is Protection of Life and Personal Liberty, which reads as no person shall be deprived of his life or personal liberty except according to procedure established by law. Article 21 of the Constitution secures two rights to every person, which are stated as following: right to life and right to personal liberty. Right to life means something more than mere animal existence. It means and includes all those means and ways by which life can be enjoyed. Right to personal liberty means the liberty of an individual to behave as one pleases except for those restraints imposed by law. Procedure established by law and due process of law. In A.K. Gopalan versus State of Madras, AIR 1950, the Supreme Court adopted a narrow interpretation of Article 21 and held that Article 21 guarantees the right to life and personal liberty to persons only against the arbitrary action of the executive and not from arbitrary legislative action. This means that a state can deprive the right to life and personal liberty of a person by making a law as the expression procedure established by law in Article 21 means a law that is duly enacted by the legislature and cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. The scope of personal liberty. For the first time, meaning of personal liberty came up for consideration in Khadak Singh versus State of Uttar Pradesh, AIR 1963, where the petitioner alleged that certain police regulations violated his fundamental right to movement under Article 19(1)(g as well as personal liberty in Article 21. The majority held that personal liberty is used in the article as a concise term to include within itself all varieties of rights. Article 19, subclause 1, deal with particular species or attributes of freedom, whereas Article 21 fails in and compromise the residue. It was also held that right to privacy is not a guaranteed right under our constitution, whereas the minority held that right to privacy is an essential ingredient of personal liberty and that the right to personal liberty is a right of an individual to be free from restrictions and encroachments. In Maneka Gandhi versus Union of India, year 1978, the Supreme Court overruled the A.K. Gopalan's case and agreeing with the approach of minority view in Khadak Singh judgment. Court held that mere prescription of some kind of procedure is not enough to comply with the mandate of Article 21. The procedure established by law has to be fair, just, and reasonable, and not fanciful, oppressive, or arbitrary. A procedure to be fair or just must embody the principle of natural justice. In other words, Supreme Court has introduced the American concept of due process of law and right to live with human dignity. In Francis Corelli versus Union Territory of Delhi, AIR 1981, the Supreme Court observed that the right to life includes the right to live with human dignity and all that goes along with it. Vis-a-vis the bare necessities of life, such as adequate nutrition, clothing, and shelter over the head and facilities for reading, writing, and expressing oneself in diverse forms, freely moving about and mixing and mingling with fellow human beings. Right to die, about right to die. In P. Ratnam versus Union of India, EIR 1944, it was held that a person has right to die. In Jian Kaur versus State of Punjab 1996, it was held that Article 21 of the Constitution of India does not include right to die. In Common Cause, a registered society versus Union of India 2018, the Supreme Court held that an individual has a right to die with dignity as a part of his/her right to life and personal liberty under Article 21 of the Indian Constitution. The code permits the removal of life support system for the terminally ill or those in coma. Court further permitted individuals to decide against life support and recognize the need for creating a living will. The judgment has paved the way for the terminally ill patient to seek death through passive euthanasia living living will. And hence, thereafter, in right to privacy, the Supreme Court's unanimous judgment in Justice K.S. Swami versus Union of India, AIA 2017, is a resounding victory for privacy. This ruling is the outcome of the petition challenging the validity of Aadhaar scheme. Nine-judge bench headed by Justice J.S. Khair announced unanimous judgment of 547 pages and declared right to privacy to be a fundamental right and overruled MP Sharma case 1958 and Khadak Singh case 1961, both of which said that right to privacy is not protected under the Indian Constitution. Life and personal liberty are inalienable rights inseparable from human existence. The dignity of individual, equality between human beings, and the quest for liberty and foundational pillars of the Indian Constitution. Privacy is unconstitutional. Privacy is constitutional core of human dignity. Privacy includes as its core preservation of personal intimacies, sanctity of family life, marriage, procreation, the home, and sexual orientation. In R. Rajgopal versus State of Tamil Nadu, AI in 1994, it was held that right to privacy or the right to be let alone is guaranteed by Article 21. This is known as the Otto Shankar case. Furthermore, right to livelihood in Olga Telis versus Bombay Municipal Corporation AIR 1986, it was held that life in Article 21 includes the right to livelihood. This case is popularly known as the pavement dwellers case. Furthermore, right to sleep in Ramila Maidan incident versus Home Secretary Union of India 2012. The Supreme Court has broadened the ambit of right to life to bring in a citizen's right to sleep peacefully under it. A citizen has a right to sound sleep because it is fundamental to life. Sleep is essential for a human being to maintain the delicate balance of health necessary for its very existence and survival. Sleep is therefore a fundamental and basic requirement without which the existence of life itself would be in peril. It is a basic human right. Few other rights recognized to be fundamental rights enshrined under the ambit of Article 21 in the representative cases are given below. Right to free legal aid as recognized in MH Host Court versus State of Maharashtra, EIR 1978. Right to speedy trial as recognized in Zainara Khatun versus State of Bihar, EIR 1979. Right to health and medical assistance as recognized in Permanent Katara versus Union of India, EIR 1989. Right to pollution free air and water as recognized in Subhash Kumar versus the State of Bihar, AIR 1991. Right to education as recognized in Mohini Jain versus State of Karnataka, AIR 1992. Right to shelter as recognized in Chameli Singh versus the State of Uttar Pradesh, 1996. Right to freedom from a noise as recognized in Ray noise pollution, 2005. Right to marry a person of one's own choice as recognized in Shaheen Jahan versus Asokan, AIR 2018, popularly known as the Hadia case. Right against handcuffing as recognized in Prem Shankar Shukla versus Delhi administration, AIR 1980. Right against solitary confinement as recognized in Sunil Batra versus Delhi administration, AIR 1980. Ban on smoking in public places as non-smokers have a right not to be victims of air pollution as recognized in Murli S. Deora versus Union of India, AIR 2002. So my this is for my smoker friends who smoke in public that there is a ban on smoking in public places as non-smokers have a right not to be victims of air pollution as recognized in Murli S. Deora versus Union of India, AI 2002. Sexual harassment at workplace is violative of Article 15 and 21 of Indian Constitution as recognized in Vishakha versus the state of Rajasthan, AIR 1997. These are popularly known as the Vishakha Guideline or the Vishakha Judgments Guidelines, who are meant to prevent the sexual harassment of a woman at workplace. Thank you.